for your time. Hello, Nana Boachi. I'm afraid Nanabi is not on the telephone. Let's try and raise Nanabi again on the phone so we can speak to him. He says he's going to the Supreme Court to seek an interpretation. Remember, somewhere in 2016, the same Nanabi went to court over the government decision to bring in some two detainees from Guantanamo Bay known as the Gitmo case. And in that particular case, Nanabi claims that there was a ruling by the Supreme Court that says that that particular agreement should have come to or gone to Parliament for Parliament to approve of it. And this is a similar situation. He comes on the back of this same issue. He joins us on the phone line again, this time around with a better line. Nana, good evening. Thank you very much for your time.
Good evening, Sammy. Can you hear me?
I can hear you loud and clear. Can you hear me?
Okay. Oh, yes, I'm good.
Sure. You have said that you are going back to the Supreme Court on this matter. Why are you heading back to the court?
Because, I mean, clearly, this is a matter you recall in 2016. Myself and Madame Margaret Banfo with our lawyer, Nana J. Bafo, we were the plaintiffs and we went to court. The action challenged the legality of the president then. You recall that the president had entered into a certain agreement with the United States of America to bring in some two detainees, Gitmo 2 case, you recall. And the Supreme Court was very emphatic. The pronouncement was very clear. The Supreme Court declared the action of the then Mahama administration unconstitutional and illegal. So I am amazed and I'm surprised as to how His Excellency the President is given another opportunity to be president again, and he's committing the same mistake he did in the first time. This is a reckless, a complete disregard for our constitution. And Sammy, hold on, let me just read a portion of the judgment to you. The language of Article 75 is perfectly clear. The article forms part of the set of provisions governing the role of the executive arm of government in Ghana's international relations. The scope of the article deals with treaties in general, and the body of the text makes reference to treaties, agreements, and conventions. It is also clear that the instrument referred to relate to Ghana's international relations and other countries or groups of countries, and the article requires that such instrument must be ratified by Parliament. And I mean, this is even a profound point. Okay, so taking into account the exhibit of A, we are in no doubt that despite the form in which it has been drafted or the text couched, it is intended to create an obligation on the part of government to the USA, whereby inter alia, Ghana binds herself to receive and resettle the two persons. So clearly, this is a matter with similar facts. We were told by His Excellency the President that they have entered into a certain agreement to bring in deportees. 14 of them have already arrived. We were told by the Foreign Affairs Minister that 40 are on their way coming. Why can't you seek ratification of Parliament? Again, Article 75 is in breach by this government. And as we speak, they have overwhelming majority. So why can't we protect our constitution? Is it a case that you have an overwhelming majority, so now you want to recklessly disregard the provisions of the constitution? This is very sad. And I listened to Okudzeto Ablakwa on your channel, ChannelOne, with Bernard Avle, where he was struggling even defend his actions. By so doing, he said that it was at the stage of memorandum of understanding, and at the time where it would develop into full-blown agreement, then they will put it before Parliament. I mean, this is ridiculous. We have already been told that 14 of these deportees are already in Ghana, and we are expecting 40. So whatever MOU you entered into, Ghana is performing a certain obligation. So why can't you put before Parliament the entire agreement? I recall that when you read Margaret Bamfo and Nana Boakye versus the Attorney General, there was a point where the Attorney General made this point in court, that portions of the agreement is cloaked in national security issues, and for that matter, it is not conducive for public consumption. The court that time conducted portions of the proceedings in camera, but yet the court said that whatever form, whatever shape, however you call it, if only Ghana would be performing certain obligations, and means that agreement, that MOU, that treaty, that convention, whatever, in any form or shape you want to describe it, you must put it before Parliament for ratification. So why should we go through this again? Why should we go through this again?
But then the defense from the foreign minister says, one, they are doing this on humanitarian basis. And secondly, it's just an understanding, more or less like an MOU understanding between the two governments in doing this. And so really, it's a matter of urgency. And so they needed to do this.
Sammy, we don't have any issue. You see, any attempt to rationalize this act, then pushing away the provisions in the Constitution, it's recklessness. How can you say that because of, or just as you just mentioned, on humanitarian grounds, you would want to disregard Article 75? Now, a Minister of State, Foreign Affairs Minister. In fact, what is even more dangerous to me is the fact that in his interview with Bernard Avler, he also mentioned that the Attorney General delivered this particular advice. And I'm amazed, I'm shocked. I know the Attorney General to be a respected law lecturer. And indeed, at the time when the Gitmo 2 case commenced, the Attorney General was the Deputy Attorney General. And he is well versed. He is aware. He is clothed with the authority to understand and appreciate what happened in court at that time. So, Sammy, I am surprised if indeed the Attorney General gave such an advice.
So you don't believe such an advice came from him?
At the point, I was thinking that maybe Okujeto was trying to, find some space to jump into because he was caught, he was cornered. Bernard read the judgment to him. Bernard declared to him that, look, what you are doing is in breach of the Constitution. And even the Gitmo 2 case supports his argument. That is Bernard's argument. So I don't know whether maybe he wanted a certain space to escape. And the only escape route for him was to bring in the Attorney General, who is the chief legal advisor, cabinet. So maybe if you bring in the chief legal advisor to cabinet, then he will be absolved from any wrongdoing. The point, that was what I was thinking. But if indeed Dr. Dominic Ayeni delivered such an advice to cabinet, then we are in serious trouble. then we are in serious trouble. Or is it a case that now the government feels that, oh, we have an overwhelming majority in government, an overwhelming majority in parliament, sorry. So for that matter, we can do anything and get away with. Is that a case? Because this is a simple matter. Simple. Now, it's not as if you are even struggling with numbers in parliament. So just put this matter before parliament.
So for you, they should just go to parliament, get this thing rectified before any process can commence.
That is the law, Sammy. Article 75 is so clear. And we are so fortunate that the Supreme Court threw that light on this matter in 2017 when they delivered that judgment. Look, and Sammy, look, finally, okay, another portion of the judgment. Consequently, we hold that upon a true and proper interpretation of Article 75 of the 1992 Constitution of Ghana, the President of the Republic of Ghana, in agreeing with the transfer of Mahmoud Umar Ben Atif Khalid and Khalid Mohammed Salih to the Republic of Ghana, required the ratification by an act of parliament or a resolution of parliament supported by the vote of more than one half of all the members of parliament, and by virtue of the failure to obtain such ratification, the agreement is unconstitutional. So clearly, you can even just expunge the name of the two detainees and put in, so for the president to agree that all of these deportees should be hosted in Ghana without the ratification and act of parliament, clearly it's unconstitutional.
You have instructed your lawyers to go back to court and commence, the process. What are you seeking from the court this time around?
To enforce the Constitution. We need to protect the Constitution. We cannot allow the executive to recklessly disregard the provisions in the Constitution. We cannot allow such to continue to fester. And this is dangerous. We are going to court, but I think that, yes, they can quickly go back to Parliament to do this. I mean, government can issue a certain statement, yes, but for Okudjato's disconnected, disjointed responses is so bizarre that it appears to me as an embarrassment.
So clearly for you, this is a clear breach of the Constitution.
It is clear. Sammy, I've just read the judgment to you. Article 75 is so clear. You see, we should not try to hide behind the form or shape of the agreement and say that it's an MOU. MOU, and we have started receiving these deportees. An MOU, and we are expecting additional 40 deportees. No. The moment you start receiving these deportees, the meaning is that you have started performing certain obligation on behalf of the country. And that is why Supreme Court said that whatever name you give to either convention, treaty, MOU, whatever, note verbal, any form, any shape, whatever name you give to whatever discussion, documentation, if it will put certain obligation on the nation, you must put it before Parliament for ratification. And I've just read it out to you.
Okay.
So it's so clear.
Okay, Harry, thank you. Thank you very much for your time. Harry Nanabuache is the national organizer of the New Patriotic Party, speaking to us there. This is Eyewitness News.